You very much, Emil. That was excellently done. Well, good morning, everybody, and good evening for those who are in other time zones, such as myself. My name is Anna Booth, and I want to welcome you here, and I want to acknowledge that wherever we are, we're meeting on the land of traditional owners, First Peoples nations, and we pay respects to their elders past, present and emerging. I'm going to begin by adding to Emil's Zoom guidance. I think everybody has in fact kindly named their picture, so that's fantastic, and shortly we'll ask you to introduce yourselves. We are just going to say a little bit about myself and my co-chair, Chris Albertyn from Canada, and our wonderful speakers. This is going to trouble me. I'm going to be saying this evening when I really mean this morning for all of you. But I am a Deputy President in the National Workplace Relations Tribunal of Australia, and have been in that role since 2012. And prior to that, worked as a consultant and many years ago as a trade union official. And Chris, who is my co-chair in this endeavour, which began at the Seoul meeting of ILERA some years ago, and really has been driven by Chris. He has to take the credit for it, and as an effort to bring together third-party neutrals from around the world to have an opportunity to learn from one another and to stimulate both good practice and also research. Chris is an arbitrator and mediator working in Ontario. He's worked as a mediator and arbitrator of labour disputes for many years. He lives in Toronto. He was Vice Chair of the Ontario Labour Relations Board for over 20 years. And he's a member and current past president of the Ontario Labour Management Arbitrators Association, and he is a member of the National Academy of Arbitrators and chairs its International Studies Committee. So welcome, Chris. A little bit about our speakers this morning. Jeanette Brazeau is chairperson of the Canada Industrial Relations Board, which is really the counterpart organisation for my organisation from Australia. That board is the tribunal responsible for mediating and adjudicating labour relations and individual employment matters in federally registered private sector organisations in Canada. Jeanette was first appointed to that position in 2014, and she's just been reappointed for another 5 years. So congratulations on that, Jeanette. Jeffrey Sack is a founding president of the Canadian Association of Labour Lawyers and adjunct professor teaching international labour law at the University of Toronto. Welcome, Jeffrey. You might wave so everyone can see who you are on the assumption that there is anybody who possibly doesn't know you. And Brian, if you can identify yourself as well, thank you. Brian is counsel to the Canadian law firm Fasken Martineau LLP with an international presence in China, South Africa and the UK. Brian's law practice on behalf of employers and employer associations concentrates on international developments in respect of the world of work. Fasken is an IOE partner company at the International Labour Organization in Geneva, Switzerland. They are our esteemed speakers for today. And in a moment, I'd like just to run you through our agenda. But before we do that, because we are a relatively small group, I think, actually we've grown, our number has grown. But I think I got consent from my organising group just to quickly, very quickly say your name and the country you're from. I think we're probably most interested in the country that you hail from, so we can get a sense of the diversity of our group. So I might actually just name you because I can see you, and you can say hello and say your country. That would be great. I'm going to use first names, if I may be so familiar. Ruchi. And you are on mute, so we'll ask our host to unmute. Ruchi from?
From Japan. Good morning or good evening or good night. I'm not sure what to say. Anyway, hello everyone.
Absolutely perfect. Thank you, Richie. Teresa. Teresa, do you mind unmuting yourself and just saying hello and tell us where you're zooming from?
I'm from Brazil, but now I'm staying in Spain.
Ah, great. Which city in Spain? Welcome, welcome. Thank you. And Ian.
Good morning. I'm an arbitrator and I'm in Canada.
Thank you, Ian. Susan.
Good morning. I'm an arbitrator and I'm from Ontario.
Thanks, Susan. Jasbir.
Sorry. I also am an arbitrator and I'm from Toronto, Canada as well.
Thank you, Jasbir. Deirdre. Would you?
From Ireland, and I'm an academic, which I feel I should apologise for, but I'm also a trained.
Deirdre, which city are you zooming from?
I'm zooming from Galway in the west of Ireland, the most beautiful place in the world.
How fabulous. Welcome. Vongai.
Hi, I'm from Zimbabwe, although I'm here in my capacity as a labor lawyer from the ILO, and I am in Ferney-Voltaire, France at the moment.
Oh, how about that? Thanks, Vongai. Pablo.
Hello, everyone. I'm from Chile, but I'm, as Vongai, as we work together, I'm also from the ILO, from the Labor Law Reform Unit. So we know Christopher, because we work with dispute resolution mechanisms. So there's also another colleague there.
Just to add, Pablo was also with Susan and Jasbir and Jeffrey and Brian also at the first meeting.
Fantastic.
Yeah.
And Pablo, where are you zooming from?
I'm in Switzerland.
Ah, lovely. Thank you. David.
Hello, good morning, good evening, or good night to everybody. I'm from Portugal, Lisbon, more exactly, and I'm a lawyer and also an academic. Nice to meet you too.
Great. Thank you, David. Beautiful city, Lisbon, hey. And here's my good friend, Joel.
Yes, good morning, good evening, and good night to everybody. I'm Black and Strong in the United States.
Thank you, Joel. And here is a a person very close to my heart. He's disappeared for a moment. Jonathan is one of my colleagues from Australia. Jonathan, you're on mute.
Hi. Yes, no, I've just unmuted myself. So it's Jonathan Hamburger, and I was a former colleague, or I am a former colleague of Anna's at Fair Work Commission, and I'm now an academic, I guess, part-time.
Yes.
So, yeah.
Great, thank you. Lovely to see you, Jonathan. Lorenzo. Yeah. Lorenzo, can I come to you?
Yes, hi, I'm Lorenzo. I'm from Montreal, Canada. I grew up in Italy and I lived also in Brazil and the US.
Very, very, very great diversity. Thank you, Lorenzo. Emil, we have already met and he's gone to a picture. Fernando.
Hello, good afternoon, good morning, good night, sorry. Sorry for that. We are talking together. I'm with Teresa Najas in the same place, so that's why it was, well, this funny noise. I'm an academic at the University of Valencia and also arbitrator, but for collective issues. You know, in balloting for worker representatives.
Excellent. We do know. And which city did you say you're zooming from, Fernando?
Valencia.
Valencia. Thank you. Beautiful city as well. Ariel.
Hello, everyone. I'm in Ithaca, New York, in the United States, and I teach at Cornell University.
Thank you so much, and thank you for your fabulous country report. Julia.
Hello, everyone. I am also just up the street from Vongai in Ferney-Voltaire. I used to work at the ILO. Well, it's a bit complicated. I'm basically on loan to the Global Deal Partnership. Let's put it that way.
And where are you Zooming from, Julia?
Just outside Geneva.
All right, thank you. I'm going to struggle with this lovely name, Guilherme, perhaps? Guilherme?
Yes, Guilherme. Hi, how are you? I'm from Brazil. I'm a lawyer and also a young researcher. I'm calling from Brazil, in the middle of Brazil, a city called Campo Grande, but I have great connections with São Paulo.
Terrific, thank you so much. Marley. Thank you, Marley.
Marley's muted.
Sorry. I am a labor and employment law professor at University of Maryland School of Law, and I am in suburban Washington, D.C.
Thank you. Now Jonathan's moved, so I'm going to skip over him and change screens, and let me see. I feel like I might have covered everybody, although maybe not. I think Cheng, we didn't hear from you. Cheng, you're coming in by audio and you're currently muted. You may not be there. Cheng.
And Silla also.
I'm going to move over to Joanna, who is obviously one of our marvellous organisers of the entire ILERA endeavour. Joanna, are you there? Maybe not. And what about Silla? Could we just say hello to Silla? No? Okay, that could be.
Yeah.
Yeah, she may.
Oh, there she's unmuted.
Fantastic. Silla, can you hear me?
Apologize. I'm talking from my office, and I've never made such a participation through my office computer, and I just realized when I'm trying here, there is no camera on that. Luckily, this was because I have to go to a technician with my laptop, and I will try to switch on my laptop, and there is a camera there. I hope I will succeed.
We all do our best, Silla, but thank you so much for joining us. Now, please, have I missed anybody? I would like not to miss anyone. Has everyone said hello? Okay. So now that we have done that, I'm very pleased to see everybody's got great Zoom etiquette and are muting themselves. And I'm going to ask Sinead Bryson, my wonderful associate from Australia, who I thought I introduced before, but I might not have. And if I didn't, this will serve as an introduction, to just quickly share screen and show us our agenda so that everybody has an idea of what we're going to do for the next little while. So this is it. So we've already dealt with agenda item 1, and Jeanette is going to take us through the country reports. Canadian developments are going to be commented on expertly by Jeffrey. Brian is going to speak about the Hague Rules on Business and Human Rights Arbitration, and then we're going to just take a little opportunity to comment on that ourselves, if you would forgive, and then we're going to have a nice open discussion. And when we do that, we'll follow the Zoom etiquette of perhaps even because we're all on screen, you can raise your hand and we'll take comments and questions and have a good discussion and then have a conclusion where we'll talk about our next meeting. And all of that is designed to be finished, I think, by 9 a.m. Toronto time, because there's other ILERA things that need to follow on. I think that is a pretty good introduction for everyone. Chris, co-chair, have I missed anything?
No, I think you're good, Anna. I think we
Okay,
can,
great.
Yeah.
Jeanette, are you ready to speak to us about all the different country reports that have been kindly supplied by many of the people on the screen?
Well, thank you, Anna, and thank you, Chris, for organizing and coordinating the study group meeting. It's a pleasure to be participating, an honor to be participating in the discussions this morning, and good morning or good evening to you all, wherever you are. my task was to review the various reports that have been submitted and to try to find, or at least I've attempted to find, some common themes that emanate, or some general themes that emanate from the reports. But obviously, there's been a number of reports submitted, about 11 or 12, and many of the representatives from the countries that have submitted reports are participating here this morning. So I'll just be very brief. Certainly not my intention to go over each and every report, but to just highlight some of the themes that I've been able to see through them. And maybe leave some time, or at the end, we'll probably have some time to have some discussions around some of those issues. And hopefully the participants from the various countries will, I'm sure will be able to share their thoughts and we'll be able to have a rich discussion around that. But certainly there's no doubt that the current global circumstances, and that's, I'm not even talking about COVID-19, but even before COVID-19, a lot of events on the world stage, whether it's digitalization of the economy, whether it's conflicts on trade that led to negotiations or renegotiations of agreements, trade agreements, Brexit, and changing political landscape that comes with a rise of protectionism or populism. Those, I think, have influenced many of the countries' approach to labor and employment regulation. And the first issue or theme that I've seen in some of the reports is really a focus to codify minimum standards for workers. And I see that some of that have emanated from probably a rise in protectionism and individualism that maybe has had an impact on or led to a decline to the collective voice that workers may have had in different countries, which because of the decline in that collective voice, governments or economies have seen them a need to regulate individual employment situations, individual employment standards. So many of the reports speak to some of those initiatives to provide greater protection to workers, or in some other cases, depending on where the country is on the political spectrum, allow more flexibility to employers in light of a rise for a need to protect and provide greater rights to employees. So I think we'll hear a little bit later on from my colleagues a discussion around a shift from soft law to hard law. And I think what we've seen in certain economies is certainly a political will to move to hard laws when it comes to worker rights. However, my question when I was reading the reports or going through the reports was, it's great to legislate and provide for worker rights, but what's the mechanism to enforce those rights? Is there a meaningful and reasonable expectation that those rights are accessible, and what are the mechanisms to enforce rights? So maybe that's a theme or an item for discussion. The second area where I saw a lot of initiatives was attempts by several countries to move away from the judicial process, and as it relates to labor and employment disputes, and to try to find alternative means to deal more efficiently and effectively with labor and employment matters and workplace disputes. So in many countries, we're seeing processes that deal with pre-adjudication, facilitation, dispute settlement options, whether it's through a mediation or a conciliation process. And obviously some countries have more sophisticated programs that even aim to prevent disputes before they emanate in the workplace. And so proactive and embedded workplace dispute resolution process and internal systems in the internal employment workplace systems. And we saw that in the Australia and the Ireland reports, very sophisticated approach to prevent disputes. In Japan as well, we saw a labor tribunal set up to deal expeditiously with disputes and with very high settlement rates. So a success story there maybe that we need to explore and think about or talk about more. So a lot of different models, but certainly the objective, the policy objective seems to be, let's move away from a judicial process and let's make this a workplace dispute settlement process that's focused on the workplace. And the third area that I identified in the reports is the role of the neutral and some of the success factors for the neutral's success rate. And I think I saw a lot pointing to elements of trust trust in the neutral function and the neutrality of the mechanism that's identified to deal with disputes. So neutrality and the perception of neutrality seem to be critical elements to success. And where, as a society, there is no faith or trust in the neutral's role, the neutrality, the authorities' neutrality, then you saw mixed results in terms of the success rate and buy-in into the alternative dispute resolution process. So that led me to think about, well, what's next, and what's the next step maybe for the study group? What are some of the key themes or issues that the group might want to think about or explore further? So I think trust is probably one element that we want to think about, and how we can promote or assist in promoting trust in the professional neutral role, and whether it's collecting or producing a compendium of professional standards that are really the core elements of trust, whether we think about what is the next step in terms of establishing, sorry, I have the sun coming in my window here, so it's splashing on my forehead.
Lovely.
But whether it's, looking at what is an international standard for neutrality and the role of the third party neutral, and maybe do more in terms of sharing the success stories that emanate from different countries. Secondly, at the beginning, I spoke of the focus on individual rights and individual rights disputes. And I think the policy objective of those initiatives are really to ensure that there's a minimum floor of rights and providing some balance or rebalancing the relationship of power between workers and the employer that has the economic force most of the times. So, but there's a question, I think, as to whether it is appropriate to have alternative forms of dispute resolution for individual rights disputes. I think there's a tension there. Some people will say, well, you have to enforce those rights. you can't mediate or negotiate those rights away. So what's the role of the neutral in that context? And I certainly, my view is, the neutral's role is to offer choices to the individuals that are facing disputes. And, but, the neutral's role is really one of the guardian of the process. And allowing informed choices. So I think that's an area to be explored further, given that there's a lot of push and initiatives to enhance individual rights and how that, what's the role of the neutral in those kinds of disputes. So I'll leave it at that in the interest of time, but I very much look forward to a fulsome discussions on some of the issues that I've highlighted. And thank you to all of those who produced detailed and excellent reports for the purpose of today's discussion. Thank you.
Thank you so much, Jeanette. That's terrific. And for better or for worse, the small steering group that's designed our session this morning has decided we're just going to press on with the next two speakers and then go for questions and comments after that, so that we can make sure that we fit everything into our time zone. So we're going to move now to Jeffrey, and in honour, I guess, of our virtual location, or the conference being held in Toronto in Canada, we're going to spend a little bit more time on developments in Canada. So Jeffrey, could you take us there, please?
Thank you, Anna. Before I begin, given the number of participants from various countries, I think I should say a word or two about the nature of Canadian society. Three things, actually. First, union density is much higher in Canada than in the US. Overall, in the public and private sectors taken together, in the US, it's about 10%. In Canada, it's close to 30%. Secondly, people are not nearly as polarized politically in Canada as they are in the US. Granted, there are divisions and regional variations and lots of right versus left conflict, but nationally, the population is and always has been 2/3 center or left of center. It's a liberal democratic society. And thirdly, Canada is a federal state, and labor relations and labor legislation fall mostly within provincial jurisdiction, while 10% of the workforce, or about 1 million workers, fall within federal jurisdiction. Through its Canada Labour Code, the federal government has historically acted as a model to the rest of Canada, and this accounts for the engaged approach to the COVID-19 crisis of Canada's current federal government, which is led by Prime Minister Justin Trudeau's Liberal Party. Having said that, as Council for Unions in Canada, involved in interest arbitration, particularly in the university sector, in healthcare, in firefighting, in police, and other sectors, I want to talk about the resolution of collective disputes. Interest arbitration, as we call it, as opposed to individual grievance arbitration. And the question I propose to address is, what has Canada got to contribute to the evolution of dispute resolution in the sphere of labor relations? Now, there's no doubt that the transmission of labor relations solutions from one country to another is not a simple matter. It is not possible for one nation to adopt measures of another without taking into account the extent to which culture and history have shaped the laws and practices of each jurisdiction. But that is not to say that common problems are not susceptible to common solutions. And the standards developed by the ILO, which have global application, are evidence of that if such evidence were necessary. Now, in my view, Canada has developed three particular ideas that could be of international interest. First, there is a notion that a constitutional guarantee of freedom of association, which is embedded in Canada's Charter of Rights, protects the right of workers to bargain and strike, and requires that where the state interferes with this right, it must be justified in doing so, and demonstrate that justification to the courts. In this regard, moreover, the right must be minimally impaired. Thus, for workers in essential public services who are deprived of the right to strike, access must be made available to a dispute resolution process such as arbitration that is independent of government and is conducted by impartial neutrals. This was decided by the Supreme Court of Canada in 2015 in a 7-2 ruling in the Saskatchewan Federation of Labour case that relied in part on international law, and in particular on ILO Convention 87 on freedom of association, as if evidencing an international consensus. And I quote, "Canada should do no less in its domestic law than it has agreed to under treaties that it has signed," as the court put it, echoing the words of Canada's most influential judge, the late Chief Justice Brian Dixon. A number of subsequent decisions of courts across the country have since applied the Supreme Court's ruling, but it is now accepted in Canada that while there should be a margin of appreciation for governments' need to make policy decisions in the interest of the public, that need cannot be allowed to erase freedom of association for workers. Thus, where the right to collectively bargain and strike is removed from workers engaged in providing essential public services, arbitration, independent and impartial and binding, must be provided. As a result, governments in Canada, both the federal government and the 10 provincial governments, no longer have the final say in labour matters. In designing legislation to implement their policy choices, whether it be for the purpose of furthering wage restraint or limiting job security, they must take into account, if the legislation interferes with collective bargaining and the right to strike, that their plans, where they are unilaterally imposed, may well, at the end of the day, be quashed by the courts if justification for legislative interference is not established. Second, I think that Canada has strengthened the integrity of the interest arbitration process through safeguards that we have developed relating to the process of appointing arbitrators who conduct interest arbitration hearings. The appointments are typically made by a government's Minister of Labour in the event of a difference as to the choice between the parties. But our Supreme Court has struck down the appointment of arbitrators who could not be said to enjoy the trust and respect of the labour relations community, on the basis that arbitration must be an impartial, unbiased process. This ruling in the so-called Hupy case, which quashed the appointment of retired judges who as a class had no particular knowledge of or experience in resolving labour disputes, was succeeded by decisions that removed arbitrators who were appointed as arbitrators despite their political connections to the government of the day. The fact that governments have a stake in the outcome of arbitrations in the public sector, insofar as they are called upon to fund the award of wage increases, makes it imperative that arbitrators be and be seen to be independent. Were it otherwise, the process would lose its very legitimacy and pressure would mount to extend or restore the right to strike. Success by a government in subverting the process would, in short, be self-defeating. In this regard, Canadians have in some quarters innovated. In several significant disputes, where there was reason to doubt the willingness of the government to appoint a truly independent arbitrator, the union succeeded in persuading the employer to agree on an ongoing basis to ask the courts to appoint the arbitrator or chair of the arbitration board in the event of the absence of a consensus on the choice of a chair. This is not because the courts are experts in labor matters, but because the long-standing tradition of an independent judiciary, whose integrity is regarded as inviolable, deters the government from seeking to influence the courts in order to secure an appointment favorable to its interest. And in practice, it ensures that the parties reach agreement on a mutually respected independent neutral. Parties in Ontario, for example, that have worked out this arrangement with government or publicly funded employers include the University of Toronto faculty, the City of Toronto Police, and Ontario doctors. Now, of course, the temptation for governments to interfere with the arbitration process does not stop at the point of appointing the arbitrator. It is not unknown for governments to attempt to interfere with arbitral discretion by imposing legislative criteria that predetermine the result, such as, for example, the fiscal position of the government. These attempts have been resisted by Canadian arbitrators who have asserted their right to assess the weight of criteria to the point of giving a particular criterion that is really a subterfuge for wage control no weight at all. All Canadian arbitrators subscribe to the principle that public sector employees should not be required to subsidize public services through substandard wages. A third contribution that I believe Canada has made is the widespread use of tripartite interest arbitration boards, composed of a neutral chair and nominees appointed by the parties. This arrangement, commonly entrenched in legislation, reflects a recognition that interest arbitration is not just an adjudicative exercise, but a continuation of collective bargaining, where the neutral chair ideally acts as a mediator, albeit with the final say in the event of an impasse. The really important contribution of the Canadian experience is that its tripartite approach serves to achieve a balanced compromise that accommodates the interests of both parties, the employer and the union. Freed from pressures by the parties by virtue of the doctrine of deliberative confidentiality, yet with knowledge of the parties' priorities that only nominees can bring, and with the aid of the chair acting as a mediator, an interest arbitration board can reach results that are far more likely to be acceptable than a single unassisted neutral could provide. Add to that the device of med-arb, or even med-arb-med, and you have the makings of a process that in Canada has demonstrated significant success. Finally, a caveat. All of the above depends on the acceptance in any country of the rule of law, in the sense that the government, like the parties, is bound to respect the integrity of the process and refrains from using its legislative power to advantage its position as employer. Canada's record in this regard is pretty good. Our Charter of Rights, which was enacted as part of our Constitution in 1982, was held in 2007 to protect workers' rights to collectively bargain and strike. However, the same charter contains a section which allows any government to pass laws notwithstanding the fundamental rights set out in it. The insertion of this section, Section 33, was considered necessary to secure federal-provincial agreement to the enactment of the charter, because of a fear that the judiciary would block passage of progressive legislation as occurred in the 1930s when the US Supreme Court quashed parts of President Roosevelt's New Deal. Use of the notwithstanding clause has rarely occurred in Canada, and this makes sense since an invocation is antithetical to the notion of a Bill of Rights that protects minorities against the will of the majority. But it is there, and it is sometimes raised as a threat by populist politicians. I say this because although I think that Canada has made advances in the area of dispute resolution, which I have described and may commend themselves in other countries, we are by no means perfect. I can only say that as a nation whose orientation is internationalist, we are open to what we can learn from others. Thank you.
Excellent. Thank you. That's terrific. Thanks so much. Well, we're going to move straight on to Brian, who I think will complement what Jeffrey's said with his, he's going to turn slightly European in his, in some of the things that he's going to talk about. So thank you, Jeffrey, and over to you, Brian.
Hello, everyone, and thanks, Jeffrey, and thank you, Anna. And Sinead, thank you for keeping us all organized. Appreciate that. I am going to move beyond Canada. I'm going to talk international. Anne has mentioned that I will reference the Hague rules recently released, but I'm going to apply a little broader lens, and I'm going to look at developments at the international level in dispute resolution as it pertains to the world of work or human rights. And when I say dispute resolution, I'm talking about the work of neutrals, whether it's arbitrators or mediators, conciliators, facilitators, fact finders. Arbitration being in a little different position because it actually involves the transfer of decisional power in a way that it doesn't to some other categories of neutrals. What I'm about to talk about is actually a follow-on to a paper that I delivered at the Seoul, South Korea World Congress that Anna referred to at the beginning in 2018, a paper called Globalization, Reverse or Reform. And it's also consistent with a subsequent presentation I made at the invitation of Jeanette, who is chair of the International Forum of Labor and Employment Relations Dispute Resolution Agencies, and they held a conference in Quebec City in the fall of 2019. And finally, I'd refer you to, there's a book that is about to be released by Wolters Kluwer, that goes by the descriptive title, Corporate Social Responsibility, Sustainable Business, Environmental, Social, and Governance Frameworks for the 21st Century. And a lot of what I'm going to say is actually contained in the labor chapter in this book that is scheduled to be released this month, later this month. So what I plan to do is give a little brief history, very brief, about the social dimension of globalization. And then I'm going to try and slice through and isolate the sources of progress in dispute resolution at the international level. I will talk about three. Two of them come from civil society, and that will include the Hague Rules, but it will also include some developments in international framework agreements and codes of conduct. And then I will also talk about a government initiative which is contained within recent trade deals that deals with dispute resolution at a macro level. So in terms of the brief history, all I will say is this. So post-World War II, there was a new world order created that has been in existence for now over 70 years, and it is quite stressed at this point in time. But when it was created following the Second World War, there were supposed to be three supranational organizations to guide the creation of the new world economy. And that included the World Bank and the International Monetary Fund. But it also included the International Trade Organization, the ITO. The problem is the charter of the ITO was never ratified by the US Congress, and so it didn't come into existence. Why is that important? Because the ITO housed the labor standards that were supposed to be connected to the new economic order, what we now know as economic globalization. And so the consequence was that for the next 50 or more years, international business was largely unregulated. And that has given rise to what was identified clearly before the turn of the century, a social deficit that was embedded in economic globalization. And so that's my history lesson, brief as it might be, but it's why there's a multitude of efforts that have been underway throughout the 21st century to try and address, to either eliminate or reduce, the social deficit that's embedded in globalization and has given rise to things like populism, economic nationalism, trade wars. This is where it all comes from. So, in terms of civil society, I said I would reference a couple of things. Briefly, on international framework agreements. These are contractual arrangements between multinational corporations and global union federations, which really developed around the turn of the century, which was the effort by the trade union movement to get on the same playing field as multinational corporations, namely the global field. And so these IFAs have kind of progressed. The first one was 1988. It involved Danone, yogurt. And in the first generation, they were quite rudimentary. But now by the third and fourth generation, sort of 2015 onward, they have become a lot more sophisticated. And these are important instruments because it is the Global Union Federation entering into arrangements with multinational corporations across lines of jurisdiction. So for example, one of them involves Ford Motor Company. Well, Ford is an American company, but it has operations around the world. So the IFA involving Ford applies everywhere in the world where Ford operates. That was the advantage of the trade union movement organizing itself on the international stage. In these third and fourth generation of IFAs, as I call them, you find more attention, among lots of other improvements, you find more attention being paid to dispute resolution. What do we do if there is a human rights dispute, a worker dispute that we can't resolve? How do we resolve it? So in some of the more recent IFAs that I would point you to, and the one in particular I'll point you to is a German retailer that goes by the name Tchibo, which is, I hope I pronounced that correctly. It's TCHIBO, Tchibo. In that IFA, you have a role that's been carved out for the ILO to mediate where there is an unresolved worker or human rights dispute. And in the event that mediation does not result in resolution, it provides that the recommendations of the ILO will be followed by the parties. That, in my estimation, is the high watermark of developments in IFAs in terms of dispute resolution mechanisms. Then I turn you to codes of conduct. Another effort by civil society, a product of the disastrous Rana Plaza collapse that killed over 1,200 workers. And a Bangladesh Accord was created as opposed to the Bangladesh Alliance, which was a less effective, I think, creation as well. But the Bangladesh Accord is a code of conduct between many garment makers from around the world and two global union federations as well as local unions. The Bangladesh Accord first operated from 2013 to 2018, and there was a 3-year renewal as of 2018. And taking those together, the first and the second Bangladesh Accord, you have significant mediation and arbitration provisions. And I will tell you, as many of you no doubt know, that 3 cases have actually gone through mediation. Well, more have been in mediation, but 3 have gone to arbitration. And arbitration involves, according to the Bangladesh Accord itself, the Permanent Court of Arbitration, the PCA, that's located in the city of The Hague. Now, all 3 of those cases went through mediation, were not resolved, and were on the doorstep, so to speak, of arbitration at the Permanent Court of Arbitration and were resolved. The terms of the settlements are confidential in terms of the parties and the terms of settlement. But again, I point you to developments within civil society at the international level in terms of dispute resolution. I'm going to come back to the point of the confidentiality when I deal with the Hague Project. So the second of 2 developments within civil society before concluding with trade deals is the Hague Project. And I encourage everyone, if you haven't already, to actually review the Hague rules that were released December 12, 2019 in a ceremony in the city of The Hague. So The Hague Project is 4 or 5 years long in the making, funded by the City of The Hague and the Dutch Foreign Ministry. There's a lot of positive stuff coming out of the Netherlands right now, I will tell you. The concept was to create a private, consensual arbitration and mediation process, tailor-made to resolve human rights disputes or abuses arising out of international commerce. So the proposal was to develop a new set of international arbitration rules, tailor-made for international business and human rights arbitration. And secondly, a new business and human rights panel staffed by people who have expertise in human rights, labor relations, dispute resolution. Everyone on this call. A drafting committee or a team was created led by Bruno Simma, SIMMA, a former judge of the International Court of Justice, and 5 or 6 other law specialists. A number of advantages were identified in terms of the Hague Project and the development of these rules and panels. The main one, I think, is independent, impartial, and expert arbitrators, mutually selected by the parties, along with skilled mediators made available before arbitration. Second advantage, hearings could be conducted anywhere in the world, even online. And that was quite visionary, given what we're now experiencing. Thirdly, costs. Courts are expensive. It's time consuming. There are some positive results, but it may not be the best way to proceed. And Jeanette actually pointed to this when she reviewed the country reports. So the third advantage is costs, reduced, affordable. That increases accessibility. The fourth advantage was that there would ultimately be a body of published arbitral awards over time that parties could rely on to perhaps resolve their disputes at an earlier stage. And the final advantage was enforceability. That arbitration awards would be enforced through existing enforcement mechanisms, the main one being the New York Convention with 157 signatory states. So as I mentioned, on December 12, not that long ago, just before the pandemic really kicked in, there was a ceremony in the city of The Hague where these rules were released. The rules are a product of a very good process, no doubt about it, that included the creation of a sounding board of over 200 individuals around the world. Some on this call may have been part of that sounding board. The work product, there is no question. It is the work of experts. It is thorough, it is clear, it is comprehensive, and it is consensual. I do have one concern, so I invite you to read them. They really have thought of everything. I have a concern that I'm going to leave with you. I hope I'm proven wrong. I wonder if it's become a bridge too far. It's too early to tell, just released in December. But it is so comprehensive. It has provisions for class actions, for submissions by third persons with, quote, significant interest in the proceedings, emergency arbitration and interim measures, the appointment of experts by the arbitration tribunal, full transparency in terms of publications about the proceedings, documentation, the decisions. And here's where I point you back to the Bangladesh Accord. Remember those cases that were settled on the doorstep of arbitration. Those settlements are all confidential. the terms of settlement, the parties. I wonder if the Hague rules, which I invite you to read, although a tremendous work product, it may go too far. I'm not quite sure what the uptake is going to be. If in fact, to sign on means you're accepting everything. Sometimes incrementalism is not a bad idea. So I'll move quickly through. There is work being done at the ABA, the American Bar Association, both the business law section and what's known as the Business and Human Rights Advisory Board Project, connected to the ABA Center for Human Rights. The business law section is trying to craft contractual language that would apply within the global supply chain system, and it would include provisions for dispute resolution, which is of interest to this audience. It is noteworthy that it is the business law section of the ABA that is doing this. Some would say that for years, maybe many corporations have said, you know what, maybe we end up in litigation, it takes a long time, costs a lot of money. These are business lawyers who are now crafting this contractual system, which tells you that way more attention is being paid to the liability that can arise to corporations who, in terms of their human rights footprint on the international stage. And I think Marley agrees with that point. And so the dispute resolution systems include non-judicial grievance mechanisms. Secondly, the ABA Center for Human Rights. There may be some effort out of there to not to create the comprehensive package, but to make available to parties model contractual language for a dispute resolution mechanism, cafeteria style. They can pick and choose and figure out what they want to do to resolve the human rights dispute. I just point you to the work at the ABA. Finally, and I won't spend a lot of time on this because I think I'm almost out of time. Moving from civil...
1 minute.
Sorry?
1 minute, Brian.
Okay. Moving from civil society to, at the government level, trade deals, I do want you to know that far more attention is being paid to labor rights, sustainability, and within these trade deals, including the European Union Canadian one, CETA, and the new NAFTA involving Mexico, the United States, and Canada, there are fairly significant dispute resolution mechanisms that have been created to deal with worker rights, labor rights. The most novel one, which will come into effect July 1, is in the new NAFTA, which doesn't just operate at a systemic level, as every other trade deal does, such as the Comprehensive and Progressive Trans-Pacific Partnership Agreement, but also at the system, at the facility company level, where panels are being created. This is dealing with companies to determine whether a factory or factories are in compliance with the labor provisions of the new NAFTA. Are those plants in Mexico, for example, now paying their workers as required $16 an hour and not $3.60 on average? Are the content requirements being followed? Those panels that have powers to do on-site inspections can actually shut down the flow of product out of those facilities to the other signatory nations, the United States, in my Mexican example, the United States and Canada. This could apply to any one of the 3 signatory countries. This is a very novel approach. It may just be North American. It may apply only to North America. I know that Canada is not doesn't have this sort of language on the table in subsequent deals it's negotiating, but I think it's noteworthy. Anna, those are my remarks. And I think at this point, I will turn it back to Chris, and thank you for your time.
Thank you. Chris, you're going to try and perhaps lead us into a group discussion.
Yeah. Right. Well, firstly, to all three of you, what wonderful talks you each gave. I mean, really wonderful perspectives on all of the aspects you touched on. I'm going to pick up on just a couple of themes. The first one is mentioned by all three speakers was the soft law to hard law transition and the extent to which we see that phenomenon developing, the capacity to enforce rules rather than have consensual agreements where parties have got to, as in the Hague rules, for example, consent to the jurisdiction and consent to third-party adjudication or mediation or involvement. And another aspect of that, which is, and Brian mentioned this in his talk about the potential liabilities to employers and why employer counsel might be interested in establishing systems that are predictable and reliable and not risk very major liabilities, is some of the court decisions, both, well, in Canada and in the UK, of companies' liabilities for what they do in other countries, in third world countries, I think is an important development, which will also assist towards the process of trying to develop some international systems of regulation and enforcement. Because once you run risks of, in your home country, of paying major liabilities for what you're doing elsewhere, that's an inducement to look more seriously at forms of dispute resolution. And I think Brian's points about the trade agreement, I mean, I think it is very significant, this recent North American agreement, that it has some real teeth for the first time. Whether it manifests like that, at least potentially, it's got the scope for ensuring real enforcement of labor standards across the three countries. Then lastly, I think also not specifically mentioned, but implied is the issue of contingent workers and people who don't have, who are not employees and are characterized as independent contractors, but are quite plainly dependent contractors and ought to be treated as employees. And I think we're seeing developments in that area. I mean, California passing legislation that Uber drivers and people with these contingent but completely dependent relationships should be treated as employees. And I think what one's looking for there is a robust approach by courts and labor boards in, say, Canada and the US to treat people who have a dependent relationship as actually employees. And that would be an important development, I think, in stabilizing labor and employment relationships. And then lastly, the point that Jeanette made and Jeffrey made with respect to the way in which interest arbitration works is the legitimacy question. How do you establish tribunals that are legitimate? And I think what's astonishing in Canada, and which Jeffrey explained so well, is that to have arbitrators determine wages and working conditions in interest arbitrations, that is, it requires a great deal of trust for the system to allow that to occur, rather than to have strikes over it, because it's got to be the equivalent of the right to strike. And it's got to be a process that's ultimately legitimate. And I think that is a real, I mean, it's a challenge that Jeanette made reference to, which is how does one establish systems where you can count on the genuine neutrality of the individuals who are appointed to chair these boards of arbitration? And obviously the value of tripartism is important in that, in establishing that legitimacy. So those are really my comments on their talks. Thanks, Anna.
Mm-hmm. Chris, I mean, you have offered, I think, some points of departure for everybody on the screen to ask some questions. I might kick off with the first question, and rather than take any more time to make comments, because I think everything that's been said is so much already. But it might just be that as I'm asking this question, and the panel is can choose, whoever on the panel can choose to answer it, others might start to think about the questions and comments that they might like to make. And as they do wish to speak, then I'll be looking for you to raise your hand or to use the little now I've lost it down here. Oh no, here we go. I lost my little thing, but I think there's a little raise hand. Here we go. There it is. Raise hand and lower hand. No, didn't work, but that's okay. We can all see each other, so we can all do that. So my question, to add to Chris's remarks, is that, you know, as I listen to Brian speak about global developments, and also listen to Jeffrey and Jeanette speak about in country developments, and echoing from the Australian perspective this trend towards individualism and actually, certainly in our case, in our tribunal, a reduction in the proportionality of collective disputes, although in our system still a very strong capability in interests arbitration in collective matters. But thinking about the world as it seems to be dividing, and the extent to which nations seem to be turning inwards, I wonder if the panel believes that the kind of international solutions that Brian's described are going to survive this kind of this kind of breaking up of perhaps that new world order, and a retreat into a self-focused approach for many of the governments of the world, and perhaps overly influenced by the UK, what's happening in the UK with Brexit and the US with Trump. But that it feels like the general thrust of the polity is against this internationalist approach that particularly Brian has described. So any comments on that? And then let's have the audience or the participants. It's not really an audience, it's a meeting. So let's have our colleagues in the meeting ask some questions too. But any comments on that and on what Chris has said?
Maybe just to first Jeffrey and Jeanette and Brian, if you've got anything to say, but after that, Susan's got something to raise.
Well, maybe just quickly, if I can. Oh, Jeffrey, where are you going? Go.
No, go ahead, Jeanette.
I was just going to say, maybe what we're seeing and what Brian was talking about, those developments on the global scene, seems to be maybe a product of the inadequacy of individual nations' ability to address some of the concerns that are emanating from global trade or from multinational enterprises. So I think what we're seeing, what Brian's talking about, is corporate society essentially taking over the rules or making their own rules, because otherwise these disputes, our national institutions are not capable of dealing with those disputes that are, emanating in multinational corporations. That's my thoughts.
No, I think that, can you hear me?
Yeah, we can, Jeffrey.
I think Brian has focused on this very issue in asking where we're going to head. Are we going to reverse direction, or are we going to reform? the system. And I think it makes much more sense to reform the system, to make it work and to figure out how to make it work. And I think that, for example, by introducing or expanding upon notions such as I refer to tripartism, we will enhance the legitimacy and the trustworthiness of these institutions. And ultimately, when these particular crises pass, that's what people are going to be looking for. Do we have mechanisms that work? And that's why I think it is important to pursue the topics that Brian talked about. I had a question myself, which is of Brian, whether the Hague rules provide for tripartism, or is it simply approaching individual arbitrators who decide the matter with supposed experts?
So Jeffrey, in those rules, you could have a sole arbitrator, but you can also have a 3-person board, a tribunal. There's provision for both of those in the Hague rules. Can I just go back though to the main question about reverse or reform? So I notice a couple of things. Number one, in this pandemic, populists, those who are trying to reverse economic globalization, they're truly struggling. Trump, Johnson, Bolsonaro, Duterte, they're all completely struggling because they're incapable of dealing with. And at the same time, what we've learned is that government is important. And so these are positive developments. There's one other positive development I would point you to, and it's been mentioned in other portions of the program. It's called ESG. This is within the capitalist world. These are corporations and investors. So ESG is environment, social, and governance. There's now over $30 trillion, 25% of all assets under management that are ESG investing. There's questions about, the standards that are being applied. We're working on that. We need harmonization. We may need regulation. But this is telling you that even within the corporate world, there is a recognition. If you don't want reversal, you're going to have to reform globalization. And what that means is you're going to have to pay attention to the environmental issues, the social issues, and the governance issues. This audience, this group that I'm part of right now, we're the S. We're the S in ESG. We are the people. We're employees. We're workers. We're the communities where corporations operate. We're the consumers. And so if you want to reform globalization, if you want economic globalization to continue, you better take care of ESG. Then you're going to have a balance between economic development and social progress. Then you're going to have something that's sustainable, that is the opposite of reversal.
Thank you, Brian. Susan, I believe you would like to either ask a question or make a comment. Yes, Susan Stewart.
Yes, thank you, Anna. I just wanted to ask a question. Jeanette made reference to the importance of trust on the part of the participants in the neutral. And that was a theme that was developed by Jeffrey in relation to developments in Canada. Brian made reference to the various structures that have been developed internationally, and Chris touched on the importance of trust as well. And I'm just wondering, perhaps the question is best answered by Brian, but in these frameworks that are being developed internationally, is there something like a code of ethics? I'm thinking about the code of ethics of the Ontario Labour Management Arbitrators Association, or the more robust code of the National Academy of Arbitrators that really establishes the parameters around neutrality and provides for an enforcement mechanism there in relation to the integrity of the arbitration system and the neutrality of arbitrators. So I wonder if, I thought that Brian might want to comment on that, but I'm interested in the thoughts of others on that issue.
Susan, that's a great question. And by the way, the short and direct answer is that in the Hague rules, there's actually a section that spells out the code, the standard that's required of the arbitrators. It's very well done. So I invite you to go there and you'll find that very code.
Thank you, Brian.
Thanks, Susan. So now open to everybody.
I think Joel is next.
There's Joel. Thank you. Go over to you, Joel.
Yeah. My question is about the future of tripartism. Institutions reflect deeply embedded assumptions, and of course the global labor institutions reflect this notion of tripartitism. But listening to Brian's comments and looking at other developments around the world, there seems to be a rise of multipartism rather than tripartitism. And by that I mean multi-stakeholder coalitions that come together, such as the 350 mayors that joined the Paris Climate Accord when President Trump said he would pull out. Many of these environmental standards are multi-party coalitions that are coming together on one issue or another and represent an emerging institutional arrangement. And so my question is, in a culture and a set of traditions over a half century old centered on a tripartite model, how do you accommodate the developments of multi-party consortia that have legitimate interest and that may even be more effective in advancing them than the traditional tripartite arrangements?
Thank you, Joel. Who's going to tackle that one?
I mean, I think it's a real challenge there, Joel, and maybe that the model one moves to is some sort of larger mediation committees so that you have representatives of a bunch of interest groups, including, say, the unions, including social groups, representatives of activist groups, and so on. And you try within that sort of committee, relatively small committee, to try and work out possible solutions and directions, and then from there, a more detailed development of what the outcome might be, so that you might then pass it off to who's going to actually write it up and how's it going to be produced, but to try and develop a consensus, bringing in all those interest groups. That might be a model that one could use.
I wonder if I could, sorry, Joel.
It raises an interesting question about who has a seat at that table.
Could I just contribute to that? I think two things from Australia. One is a development in our tribunal, which is a conciliation and an arbitration tribunal and has been since 1904. But more recently, in the interests arbitration of terms and conditions of employment under what are known as awards that cover occupations and industries. Through our statute, we've jettisoned the primacy of the industrial parties, that is employer organisations and unions, in favour of essentially anybody being able to make a submission that they wish. And probably our annual wage review would be the best example of this, where not only is our annual wage review available for any of the social groups to contribute to, and many do, but also the arbitrators aren't exclusively members of our tribunal. There's some expert panel members who are appointed by the government, economists and social experts and the like. And so that's just an interesting, example of how an institution's changed itself to embrace a greater number of stakeholders. The other point would be that I think to pick up what Chris has said, I think that the traditions of mediation and the capabilities of mediators are absolutely refined and the capable group to bring in to deal with multi-party situations in a way that litigation finds very challenging, because with litigation you have a whole bunch of concerns around standing and interest, and it's quite an exclusive a territory for people to have to justify their interest to actually have it, and then the way in which the decision is made is quite binary, you win or you win, and correspondingly, of course, the other party loses. So, and certainly in Australia, we do have some history of this, not enough, much more could be done, but just recently doing some work across the care sector, bringing in not just the employers and the unions representing workers, but the funders of the care sector being state governments often in this particular circumstance. That was a bit of a unique development, and I definitely think that mediation, as Chris says, provides the skill set and the framework that's right for multi-party involved consensus building. Joel. Watching our time, but please let's have yes, Pablo, excellent. Let's have a question, and then Ruchi after Pablo. I think I saw Ruchi, so it's Pablo yes. And then Ruchi.
Thank you, and well, thank you all three presentations, and were very interesting. And again, thank you for the co-chairs for this session. I know I'm an official, but I would rather do a very personal comment. So this is a disclaimer made. Yeah, sure, but now we're all aware of many distinctions that you have presented in different ways about individual, collective disputes, or different kind of dispute mechanism, different kind of cultural arrangements. It will change everything. And I think we're all aware of how this dispute mechanism have a key role for stable industrial relations. And yes, we're all aware that now global economy, we don't know where it's heading. We want something, I don't know exactly what, but we don't know exactly where it's heading. But in that concern, maybe the idea of compliance and enforcement is still missing, needs a little bit more development, especially the idea of compliance. But I mean, just the idea of a natural compliance to fulfill legal obligations. So that is a little bit missing. Maybe I need more development on that. And regarding the trends, there is something I actually would like to ask the three people who speak, and generally everyone, and maybe Fernando, I don't know where he is, because this one of the trends today is the link between, for example, well, anything with technology. So if we link, in particular, individual disputes to technology, it means that at anywhere, any place, a mediator, arbitrator, conciliation could deliver the process and the final decision by, for example, using Zoom or Skype or any other platforms. But to me, that raises also many legal questions, as for example, if there is some sort of a guarantee for due process and access to justice. I mean, I don't know if anyone have thought of this before. I know that in Spain, that's what I pointed out to Fernando. This was the case for the first 3 trials that were made, I think, on Skype and Zoom on different regions in Spain. That was the question, because those trials were very short, very quickly. And in other countries in South America, we're aware, also there's also the discussion on, there's very, very easy to breach the rules, the procedural rules. So there is the witness by Zoom, and suddenly, oops, sorry, judge, internet connection failed, and came back and the right answer, magically. So I don't know if, but this is happening today. I mean, there are many countries that you cannot go to the audiences live because the buildings are closed, or many other reasons, not necessarily linked to COVID. But there are many other reasons that actually there is this shift to technology. There's a shift, everything to tech stuff. So this is an open question. To me, this may raise several concerns regarding access to justice and due process. So if maybe the speakers or anyone can
well, because we only have about 5 minutes of our time left, I'm going to challenge our panel and ask them to remember the comments that have been made and give them 1 minute towards the end just to comment on everything. But I'd like to hear more of the voices of our colleagues who have participated. So let's hear from Ruchi and get at least one more comment in before we have our panel wrap us up. So Ruchi.
Thanks, Anna. My comment is about tripartitism relating to Joel's question and also the trust factor mentioned by Jeanette. Maybe tripartitism has 3 functions. The one is expertise. The second is voice in the decision making. And the third element is sort of the legitimacy, the giving legitimacy to a certain system. And as long as the dispute resolution is concerned, the expertise factor seems to be important because tripartite expertise based on tripartite composition brings trust to the parties involving or participating in the dispute resolution process. So one of the reasons for the high success rate of the mediation or labor tribunal system, I think, is tripartite composition of labor tribunals. So that depends on which process we are focusing, the dispute resolution or political decision making, etc. That's my brief comment.
Thank you, Ruchi, very much. Is there one more person who'd like to either make a comment or ask a question? Yes, Teresa. Teresa. And Marley, I think you want to do it. Is that too, Marley? So can we go Teresa and Marley, and then we've got probably 30 seconds each after that. So Teresa, quickly.
Just 1 minute. First, thank you for this opportunity, and it's very nice to hear it you today. And congratulations for the proposition, and thank you for all the presentation. Just one thing, Brazil is very late on this topic about arbitration. In the last reform in 2017, you have a big labor reform law, but the labor law in Brazil still is very paternalistic and specifically designed for subordinated workers. The other types of the workers are marginalized by legislation and do not have adequate social protection. And all issues must be resolved in judiciary. And for everything, you need a judge and you need a judiciary power. This is a big problem for individual conflicts and for collective conflicts. We have a law about the arbitration. It's not a bad law, it's a good law, but there is a big resistance for the judge for accept this legislation for labor conflict or labor prevent situation. In the reform from 2017, allowed the establishment of the arbitration clause in the contracts of workers who have higher education and receive but the equivalent of 2,200 per month. However, this situation is highly questioned and there is a lot of resistance from the courts to accept in any situation arbitration or extrajudicial mediation in individual conflict. Arbitration and admissibility is only for collective conflicts, but you have a problem because every time when the for collective cause the people doesn't have agree, the conflict go to the judiciary because you have the collective demandas with the that for the employers and for the association by employers and employees. This is very difficult, and the judiciary doesn't have interest in accepting the arbitration and mediation.
Teresa, if I might I ask you just to, it was so interesting, and I wish we had another half an hour, but can I just ask you to finish up? And then I'm going to ask Chris, do you think we have latitude for 5 more minutes? Just
1 minute more for the
5 minutes for Teresa, but just because we need to wrap up. Yes, Teresa, just
with the COVID-19. We have a growth about the virtual process and the pre-mediation process, but everything in judiciary. This is the big problem for us. Thank you very much. And sorry for my English because I'm very.
No. It's appreciate the diversity of I mean, this is where the governance of a country is so critical. So Marley, you just wanted to say a quick little thing. Let's let you.
Okay. So number 1, Christopher is right about the importance of California's ABC law, which makes dependent employees into employees for legal purposes. That is spreading. That is, New York State is considering adopting similar legislation. A number of other states are likely to follow that model. So if people try to opt out of being employers and cut their employees into a totally deregulated mode, the fight back that develops is likely to produce exactly what they're seeking to avoid in the first place. Second of all, I totally agree with Brian about the importance of the USMCA, also known as NAFTA 2.0, and its dispute resolution procedures. Third of all, I happen to be a co-chair of the American Bar Association Labor and Employment Law Section, Immigration and Human Trafficking Committee, which opposed in the ABA's big deliberative body the proposed model rules being adopted as a statement of the body of the body as a whole with regard to supply chains that the business people came up with. And that was exactly because of the point that Brian was making, namely that they were largely aimed at diffusing liability exposure, and also they were very soft law and hortatory rather than creating something binding. And which is a statement of the internal tension within a body of lawyers in the United States. The business section does not have the consensus rule that the labor and employment law section has, requiring both labor and management to agree on any output before it goes to the full American Bar Association bodies.
Thank you, Marley. Chris, I think if the panel will accept this, I think that many of the comments and Teresa's absolutely important comments as well, and I apologise for having to move you along, Teresa, but I think all of these comments just highlight how important it is to have these discussions and perhaps to have even more time set aside than we did this morning. But Chris, you've got something to say to the group about continuing this dialogue and how we might do that and when we might do that. So I think it's the right time to ask you to speak about that now.
Okay, thank you, Anna. I think we've had now 2 meetings. Our first meeting was in Seoul 3 years ago or 2 years ago, and we've got a meeting planned in Lund in Sweden next year at the ILERA World Congress. I think we also need a bit more of an ongoing exchange between us. So I think what Anna and I will do is to think of a way of using maybe some app or some mechanism whereby we can communicate ideas that relate to the questions we're interested in, which is forms of dispute resolution, developments that are occurring worldwide. I mean, Brian, a bunch of the things that you raised are fascinating for us, and many of us don't know about those things. So that if we could have a repository where people could, you know, for example, the developments, let's say like the Hague rules being produced, that a copy of that is put in there, and other exchanges that are relevant to our work and our thinking and to enforcement and these kinds of developments, we could share that in a forum together, and so that we have some ongoing engagement. I mean, the original idea of this study group was to engage practitioners and academics together, so that practitioners learn about the work that academic people are doing, and so that academic people learn about some of the challenges that are happening from the practitioner side. That was one aspect. The other aspect was trying to understand each other's systems and trying to understand international development. So the other thing that I think is anybody who's not on the list of the study group should communicate with Sinead Bryson. And Sinead, maybe on the chat, you can just type out your email address, that those who are not on the list can write that. Oh, you've written it down. That's excellent. Okay, so anybody who's not currently a member of the study group, be very nice if you would join the group and be in touch with the rest of us. And I think those are my comments. I see that Gustavo's got his hand up. Do we want to take a last comment?
A final question. We're 8 minutes over time, and I don't know what that means for ILERA, so I don't want to be, but where are you, Gustavo?
No, he's not.
You have to shout out.
Okay, we'll leave that. All right.
Yes.
So
okay.
Well,
Well,
to seeing everybody in Lund, and hopefully you'll get.
I think we say goodbye, and we thank you very much for coming and for your contribution this morning. Everybody who's got a day ahead of them, have a great day, and everybody who's got an evening ahead of them, have a great evening.
Thanks.
Thank
Anna.
you.
Thank you.
Thank you so
Thank you,
much.
everyone.
Bye, everybody.
Bye, Grace. Bye, Anne.
Bye.